everybody, welcome back to another episode of Debt Collection 101 here on Arbeit U.
This isn't just any episode, Alex, right? We usually do a big intro here, but we got to make this much quicker because our guest today is charging us by the hour. So we have to kind of speed this up so we don't lag on for too long.
Yeah.
We're joined today by partner at Feynman, Kreckstein, and Harris, actively involved in the industry. Everyone probably knows him. If you go to any ACA event, you've seen him. Also, avid Netflix enthusiast, Richard J. Perr. How are you, sir?
I'm doing well, and you guys, how are you?
Good.
Doing well. Thank you very much
That
for
was
asking.
quite the introduction.
Well, you know, I like to pump up our guests a little, pump the tires. So we're talking today about the current political climate, which is why obviously, you're a great person to have on. So do you want to start by telling us a little about yourself?
Well, I'm a partner at Feynman, Kreckstein, and Harris in Philadelphia.
Mm-hmm.
We do a lot of defense work and compliance work in the industry throughout the United States. We've had a lot of interaction with some of our friendly government regulators, both in Washington and in the States. And, if the weather was actually nice, I'd probably be playing golf today instead of talking to you guys.
So would we if the weather was nice in Buffalo, New York.
Yeah.
So I guess first question, pretty generic right off the bat. Trump administration, overall good or overall bad for collection agencies? What's your thoughts so far?
I think the climate so far has been a complete 180 from what we've seen in the last 8 years. There's a real tone in Washington that regulation is not just in a protection mode, but it is also to ensure that businesses maintain an equal footing to be able to compete in the marketplace, which has always should have been the message, regardless of Democrat or Republican, because the credit and collection industry brings back to the tune of about $68 billion back into the U.S. economy. It's not a Democrat or Republican issue. It's an economic and viability issue. While we all want to see bad actors punished and taken to task for breaking the law, at the same time, we don't have to create additional burdens on those good actors who are out there in the industry. And this administration gets that. You can see it from their pronouncements. You can see it from the tone and manner in which they're going about their responsibilities holding office. So it's really been a sea change and a welcome one at that. And I think that everyone in the industry can see that. And I think to a certain degree, it bleeds into court decisions. It bleeds into decisions by regulatory bodies as well. The industry can be extremely pleased right now with the direction that the country is heading in with respect to financial services industry. And now is the time to be engaging in activities to really beef up your businesses.
Are there any big decisions or things on the horizon that you think agencies should be waiting?
Following?
Yeah, waiting to hear.
Well, I think there's a number of topics. First of all, and I know we'll talk about it, I'm sure, in a couple minutes, the decision by the United States Court of Appeals for the D.C. Circuit in the ACA versus FCC case created a really, I think, bright line test about the extent of the powers of the Federal Communications Commission. And what we're going to see is, as the confines of that decision need to be massaged by the Federal Communications Commission, we're going to see that go back to the FCC. So there's going to be a whole flurry of activity to really get down to the nitty-gritty of some of those definitions at the CFPB. That clearly, and I think that you would find that most industry people would agree that you need some clarity with respect to the Fair Debt Collection Practices Act and some of the rules there, and the implementation of real rules with real clarity to remove some of the ambiguity that the statute allows the court system to manipulate. So I think that we're going to see at some point, it may be some time off, but we're going to see rulemaking which will be vastly different than the rulemaking that would have come down under Cordray. I think this rulemaking is going to be more in tune with defining specific duties
Yeah,
That's
and-
much neat. That would be. I'm sure that's music to
everyone's ears. And one of the things you brought up was obviously the difference between Corduroy and Mulvaney, right? And I don't know. I mean, I'm sure you saw his annual report to Congress. I mean, first off, there was like 4 things, and you can correct me because you're gonna know much more about this than I would, that he that really stuck out, right? But some of them seemed like they were really like basic, right? But the one that really like interested me was his opinion that states should be in charge of regulation over the federal government. Because at the same time, obviously, you got Betsy DeVos going saying the exact opposite, right? She's saying as far as student loans goes, that should be a federal issue over a state issue. So where do you fall in that debate? You think it's better in the long run for states to be in charge of that, or for the federal government itself to be in charge of that?
You know, that's a really tough question, because you did bring up 2 ways in which there's that dichotomy. The Department of Education is talking about its student loans and money that's federally guaranteed, and they view as having states control the manner and method by which their vendors have to act to be contrary to their desires. They want a uniform production. They want to be able to say that their vendors do X, Y, and Z. They want to be able to control the process. So there's definitely, it's definitely understandable why the Department of Education wants uniformity with respect to how its vendors act. On the flip side, it has always been what I will term a more conservative principle, that states get to be the main proving grounds for a lot of generic activity, and that the federal government only have those powers, be it necessary to do things on a nationwide basis. And so when it comes to enforcement of regulatory conduct, I guess the FDCPA has been written in a way that doesn't preclude states from enacting their own trade regulations with respect to trade practices and debt collection.
Really?
So,
yeah, you see that a lot.
Yeah. So unlike the Fair Credit Reporting Act, which preempts state action, the FDCPA does not. And there are a number of statutes many people are aware of, such as the Rosenthal Act or the extensive regulatory activity in the state of New York, in the city of New York, and in Buffalo, as you guys are aware of.
Yeah.
And so, you get these independent and individual activities. And so what the federal government is saying is, with respect to enforcement, is I think they still intend to enforce to a degree the FDCPA, but what they don't want is to have multiple actors pursuing the exact same enforcement actions and piling onto agencies and leaving it to each individual state to take care of the regulatory activity within its jurisdiction under its state laws, and not to take the role that the CFPB did previously, which was to come in and, while maybe not specifically enforcing activity that was under the Fair Debt Collection Act, Practices Act, but more or less utilizing its UDAP powers, this general blanket power that Congress gave it to deal with any unfair, deceptive, and abusive practices, and they used it like a sledgehammer. I think what Acting Director Mulvaney is really trying to say is the CFPB is going to step back from UDAP and really allow the states to take a hand in policing that type of activity to the extent that it runs afoul of state regulatory practices. So there is that sort of difference between the statements by Ed and by the CFPB, but if you really get down to its core, I think they're a lot more similar in theory and in concept and in practice and in a conservative viewpoint of politics than dissimilar.
Yeah, and because that's like one of the things we get a lot is like, you'll have like this one state have a ruling versus another state, and then they're like, well, I'm not as worried about that down here because this judge said that, versus someone in, let's say, New York who has a complete opposite standpoint. So like a universal way of doing that would help us, honestly. So we're in favor of that.
And I think that's to the extent that there's going to be rulemaking, but when it comes to enforcement,
Yeah, right.
and that
makes sense.
Remember, Rick Cordray wanted to use the enforcement power as a way to regulate.
Yeah.
Mulvaney has clearly said he's not planning to use the enforcement power of the CFPB to regulate actors. They're going to do that through rulemaking, which was something that Cordray never got around to doing.
Yeah, I mean, yeah, makes sense. Good for us. So final thing I want to do is I want to grab your reaction to that D.C. Circuit Court of Appeal. You mentioned it earlier. What's your opinion on that?
I mean, I think it's an extremely positive decision for the industry, and maybe not for some of the reasons that appear on its face, but I think that the unanimous pronouncement by the D.C. Circuit Court, which was primarily Democratic-appointed judges, who came out and said that the FCC overreached in its application of rulemaking, in essence, and it really wasn't rules, but it was a declaratory order, which is, it's the same effect of rules, and saying that went beyond the language that Congress put in the statute is a very promising pronouncement, because it sends a message to all the rest of the courts in the land that going beyond congressional language to reinterpret a statute, in this case, on the back of an excuse of modernity, and saying that, well, in 1991 there weren't cell phones like that, and there weren't auto dialers, and there weren't communications like that, and therefore Congress intended for it to be more expansive. And this court to say, no, Congress intended what it wrote. Congress wrote it in 1991, and if you wanted to address more modern technology, then it's up to Congress to change the rules and to make a new statute. And I think that's very important in a governmental structure. So what that sends the message to is it sends the message to other courts on not expanding the scope of the written word in the TCPA. We already saw that happen in Marshall versus the CPE group, where a trial court then went ahead and parroted that exact same language and refused to allow plaintiff's counsel to proceed in a case where the device that was being used was not a random or sequential number generator, which was the language used in the statute. And it sends that same message back to the Federal Communications Commission to say, when you get this case back in front of you again, and when you reconsider the definition of an automated telephone dialing system, you need to keep in mind that your delegation of authority only goes to the extent that Congress has written its word down, and you cannot go beyond that written word. So again, that is extremely positive for the industry, and I think that what it really means in a practical sense is that we will see a future where the predictive dialer in and of itself, because it's a predictive dialer, will not be considered an ATDS unless it otherwise exhibits characteristics that contain functionality that has been defined already in the statute. And I think that realistically, we can anticipate that Congress will in no way, shape, or form enact another statute, because they just can't get their act together to do other things, let alone deal with the TCPA. So I think for the industry, it's a good decision.
Yeah, I think so too.
Yeah, that's great news, I'm sure.
Yeah.
Everybody watching, I mean, it's been, I think a lot of people have been waiting for that.
Yeah,
So,
sure.
that's, yeah.
And I think it's an extremely positive for many companies like yourself who are in the technology space to be able to have some clarity and some assurance, and you're able to communicate with your clients about risk-reward in a really upfront, clear, unambiguous pathway that they can make the decisions for themselves without some hidden event occurring somewhere down the line that really nobody could realistically anticipate, but which could be very injurious simply because you get a runaway court. And I think that what this decision does is put the brakes on that possibility from really realistically happening. And I think it's good for a lot of the people in our industry on the technology side to be able to really be able to talk about clients about improving their processes and making them more efficient and more effective.
Yeah. Man, that was great.
Yeah, that was some good information.
Yeah. Final question. When are you running for Congress?
As somebody who did a long stint in being I think the answer is not really.
Never
Or
again.
in the near future.
Yeah.
But in all seriousness, it really takes a lot. I've been behind the scenes. I've helped get members of Congress elected. You have to have a real commitment to putting aside almost everything else you're doing to really run for office. While I highly recommend people out there in the industry, if you're really thinking about it in your communities, there's nothing more rewarding from holding office. But you just got to go into it with open eyes and understand raising money, communicating takes a lot. And at this point in time, with 2 young kids,
Yeah.
and, college to pay for, and a handicap that needs to get down, running for office is not in the near future.
Yeah, I like the ranking of those priorities. That was
Yeah.
good. I'm sure everyone will appreciate the golf being at the bottom.
All right. Well, yeah, thanks so much, Rick, for joining us. That was great. I'm sure everybody watching learned some new.
Yeah, I wrote look at all this
Yeah,
stuff I
Spencer
wrote.
was there taking notes.
I was taking notes as you were mentioning stuff. I'm like, I gotta research that later. So, but thank you for coming on. We'd love to have you back if you would be open to it.
Oh, yeah, you're scheduling one right
I
on
appreciate
here.
the opportunity to join you guys, and I'm just a phone call or a Skype session away. So
We're definitely doing the
happy to
face-to-face.
help you out.
Yeah,
All
we're
right.
definitely gonna do the webcam next time. So, thank you very much for watching. As always, subscribe, like the page below, and we will see you next week.
Thanks. See ya.